But the one thing that I wish we had talked about more on last week's show when we talked through that case is I wish we had explained a little bit more about what happened in the Google case, because what was going on there, and correct me if I'm wrong on any of this, but I think Google had scanned and digitized like millions and millions of books and made them searchable as part of its Google Books program. And they made the entire books available when the books that were scanned were in the public domain. But when it was a book under copyright, there were only a handful of pages that were made available.
Right, like 5 pages or something like that. Yeah.
Right. And that context is important because you and I were talking about the Google holding, and we didn't really explain what the facts were in that case. But there's a clear difference because obviously, it's obvious to anybody that the snippets of text available on Google Books were not going to be market substitutes for actually reading a book that you find on there. So Google clearly wasn't harming the market value of the original work.
Right. In fact, they were arguably enhancing it, which the judge sort of held. Because if you can read 5 pages of a book, are you more or less likely to buy the whole book?
Right. And so when you spin it forward to the present scenario, there is more fuzziness as to what the end game might look like for incumbent media if chatbots suddenly become like the dominant resource that everyone uses for news and information gathering on the internet. And so that isn't even to argue it one way or the other. I'm just saying, like, in an objective sense, the 3-page sample was not a competitor to authors. And the question is not as obvious if you imagine chatbots in 5 years. And then the other thing that I think is relevant.
Just to jump on that, I mean, I think this was sort of the broader point I was driving at in the article I wrote last week, which is in this sort of offline world, in this sort of analog world, in this world with a lot of friction, you really did build enduring value by building sort of permanent things like a book, right? A book is something that is there and long lasting. The problem with to your point, when it comes to the internet, is news is not valuable in a sort of financial sense, because once it's out there, it's out there,
and you can't copyright facts. Yeah,
that's right. And so the truth is that real value on the internet comes from the continual production of content, but in a way that people find ongoing valuable. It's not like sort of the junk site just churning stuff out, but it's like Stratechery. I like you come there every day and there's going to be new stuff, and that new stuff is valuable. Stratechery is valuable because of the promise I make to subscribers that I will keep producing stuff that you will like, and they're paying for the ongoing production. If I just put Stratechery on the web with a paywall and said, hey, come here, read my article from 6 years ago about XYZ, about a current event that happened then, and yes, there's timeless truths in there, you just have to figure it out based on the context of what happened, it wouldn't be valuable at all, right? And so, like, could I sell Stratechery for a high price? No, probably not, because the real value is in the sort of ongoing production. And for a long time, I viewed this as sort of a weakness of my model, because that's a real cost. You have to sort of keep doing it. But I think there's an aspect, that's just the reality of the internet. You can't build enduring value on the internet. The internet is all about right now. And to the extent you build value, it's that you promise that the right now in the future will have content for you, because I've shown that I'll keep doing it. You can read all the past stuff, not because it's valuable, but as an attestation to the future value you can expect.
Well, and correct me if I'm wrong, but if there were 500 Ben Thompsons and Stratechery had been publishing for 125 years, Stratechery would have more value as a training data set than
but not that
a bunch
much,
of random websites.
Speaking, I think, just to be totally honest, like these. There's so much data that goes into these. Like, how much worth is one particular thing? Now, the New York Times, for sure, as they note in the lawsuit, we're like the fourth most, like, we've brought the
high
fourth
priority.
Most
yeah, exactly.
So I'm not denying that there's value, but the enduring value of the New York Times, and again, say what you want about the New York Times on all sorts of factors, whether it be, politically, socially, fighting with tech, whatever it might be. From a business perspective, it's an incredible triumph, because they transition from being this real world, producing an artifact every day that you bought, to being a real internet company that provides value, not based on one particular event or buying one particular story, but on the promise of continued content that you will find valuable, right? And they make a credible promise that they can sell against. This is a peacock problem. What's their credible promise they're selling about ongoing value? They're trying to sell one thing, one game, right? And that's sort of the fundamental problem with their business. Whereas Netflix is like, look, we're going to always have new content there that's always going to be there, right? Now, maybe it's not going to be spectacular, but like it's not like
worse.
I mean, maybe not any one thing is going to be NFL quality, but this is where the internet is different. It's all about the internet is all about what have you done for me lately. Selling on the internet is promising that you can answer that question on a continual basis.
Yeah. No, and the only reason I make the point on 125 years of stratechery with 500 Ben Thompsons is because, yes, you can't copyright facts, and facts don't have value in a copyright context, but that isn't where the value is being generated in the case in terms of what the New York Times is actually arguing here. And it'll be very interesting to see how it shakes out over the next however many years, because the other factor, when I was looking back at the Google case, there's a big difference between being a big tech defendant in the mid 2000s. That case ran from like 2005 to 2015, and being a big tech defendant from 2024 to however long this case could run. And that isn't a value judgment on tech or anything. It's not even an endorsement of that view, but just from a strategy perspective, it's worth keeping in mind that a company like OpenAI, a company like Microsoft, they are less sympathetic now than Google might have been in the mid 2000s. And both those cases were filed in the Southern District of New York, and the Second Circuit ruled on appeal in the Google case. So there's a lot of overlap, but there are some key differences to keep in mind. And for that reason,
on here, by the way, just to jump in, this point is a really good one that you're making. And the reason we got back onto the fair use question is fair use is so kind of like
subjective.
Cloudy, right? It's a balancing test. All this stuff goes in. And one of the challenges here is it's not clear how or what you can do in the space because there are not any clear lines. And you can understand how that can have sort of a dampening effect on innovation in some respects, right? What can you do? What can you not do? Do you want to be Napster? Do you want to be sued to oblivion? Or can you sort of pull it off? Well, Google is a big company. They can afford lawyers and they could sort of manage it, I think, with a good outcome. But this bit about the fuzziness and subjectivity, it's kind of nerve-wracking to know that this is going to be up to some sort of random judge in the second district to sort of determine the future of the most important technology going forward. This is why, just as an aside, there was a move in antitrust law for, all you folks want to complain about the 80s and Reagan destroying antitrust law. This is where the impetus came from back then, where it was in the 60s and 70s, it was totally subjective. It was just totally random. What is bad, what isn't. Everything was politically driven. And it's important to keep in mind that the drive towards quantitative measures like market concentration and all these sorts of things and the economic sort of value or payoff, which everyone sort of complains about today, that was a pendulum swinging where there was a real need for more stringency, because you were actually hurting innovation by virtue of the fact it was totally random on what you sort of could or could not do.
Right. Yeah, no, and I think
I don't want to trigger an antitrust point. Just this bit. I just feel like with this fair use one, you can sense that there's a discomfort in the fact there aren't any bright lines. Now, there's value in not being bright lines, because who could have predicted AI if there was a fair use written down in stone that you can't ingest an entire work?
Illegal.
You would have already killed this whole thing, right? So I'm not making a judgment one way or the other. It's just an interesting way to think about the value of subjective laws versus objective laws versus like writing laws too early, too late. By and large, I think fair use, it probably can only ever be subjective, to be totally honest.
Yeah,
just because
I go back to my analogy for both antitrust law and fair use is it's like the NFL, keeping with the theme today. You can't legislate the exact parameters of what a catch is, and the more precise you try to make it, the more maddening it's going to become for everybody. It's just undignified for everyone involved. In any event, all of that is the reason. All of that is why I would guess that OpenAI is going to be very open to a settlement as things move forward here, because I wouldn't want to end up in court doing discovery on any of this stuff. And I also think that just from a strategic perspective, it's not as strong a position as I may have let on as we were talking through it
Well, I think that's a
on the
really good
last
point.
week's show.
It's definitely in OpenAI's interest to settle.
Yeah.
And it's probably in the industry's interest to drive it to a conclusion, right? To sort of get, and so there's some aspects where OpenAI is sort of the wrong sort of defendant in this case.